I do believe her. I do think this happened, but I can't prove it.
The court notes that this is a significant departure from the actual charges.
The detective on this case had a Rule 16 violation. It had malfeasance with lots of SVU cases, including this one.
Eisenman, on behalf of Mr. Oga, he appears out of custody.
And I do have before me a plea agreement of the parties. It indicates that Mr. Oga is willing to plead guilty to count 3, assault in the 3rd degree, knowingly or recklessly causing injury, a class 1 misdemeanor. Counts 1 and 2 would be dismissed. It would be 2 years of supervised probation. He must comply with a mandatory protection order. He must complete 16 hours of boundaries therapy class, and he otherwise waives his rights pursuant to criminal procedure 35B. Ms. Heisman, is that the plea agreement in this case?
It is, sir.
All right, people agree as well?
Yes, Your Honor, but the victim does object to this plea, and she would like to address the court.
All right, I will hear from the alleged victim in the matter. Ma'am, can you go ahead and tell me your name?
Yes, my name is.
Thank you. I have you listed as the victim in this matter. I've read the proposed plea agreement here. My understanding from the prosecution is that you'd like to address the court related to the plea agreement. Go ahead, ma'am.
Yes, my intention here is to simply make my voice heard as to why I believe that this is an inappropriate way to address this matter, given the severity of the nature of the crime and what actually happened to me. I understand that my victim statement has hopefully distributed, but I would just like to read it aloud one more time to hear it so that you can hear it just from my voice, if that is all right.
Well, normally I would hear that at the end of any sort of disposition if I do accept that. Well, then what's your position as to how the court should do this?
That's all right.
I don't know what she's going to say if she wants to address the court before I actually even accept the plea agreement.
I can wait until after you accept it or not, as
Okay.
whatever the court's protocol is.
Okay.
I will.
So, yeah, so I'll certainly, you have every right, and I'm going to hear from you. Just the timing of it is what I want to know about. So my understanding is that you are not in agreement with the plea agreement. That's what I'm asking right now. Is that correct?
Yes, it just, as a victim, it doesn't sit well with me to know that there really is no admission of guilt of the sexual violation. It's a much more severe position to be in than simply being assaulted by happenstance or some sort of reckless motion. I truly do believe that this was an intentional abuse of power and that this person is absolutely dangerous to the community and absolutely has the potential to harm young women continuously.
All right, thank you, ma'am. I will, again, give you an opportunity to speak to the court if I do accept the plea agreement. Thank you. Ms. Oldham, I do want to go back to you. The court notes that this is a significant departure from the actual charges in the matter. I'll let you make a record on that. Go ahead.
Absolutely, Your Honor.
And I'll just say this, I'll let you talk here in a minute. The highest charge was a class 3 felony. Go ahead.
Yes, as I spoke with her before about this offer, as I told her, I do believe her. I do think this happened, but I can't prove it. I don't have a likelihood of success if we did go to trial. The detective on this case had a Rule 16 violation and did not investigate, had malfeasance with lots of SVU cases, including this one. Because of that, it calls into, I think it would be difficult to have a detective who has now been fired, who has a Rule 16 letter, who also didn't do everything she was supposed to do in this case and in other cases. I am quite concerned about going to trial with it.
All right, thank you. All right, ma'am, I'll let you go ahead with that record from the prosecution. Is there anything else you wish to say? I did hear from you, and I'll let you say anything else that you want, including the fact that, as I normally do, if I do accept the plea agreement, I'll still hear from you again at that time. Is there anything else you wish for me to know now before I contemplate whether or not the court will accept the plea agreement? Go ahead now.
At this moment, no, I can wait until the appropriate time to read my impact statement.
All right, thank you. I appreciate that, ma'am. All right, the court's familiar with this case. In fact, I was the judicial officer who reviewed the order for warrant and the complaint and information. Though I read the affidavit and I can tell what the allegations are and whether or not there's probable cause for that, what comes down to whether or not there's provability and discovery in the matter that often is left more importantly, to the attorneys themselves. And another way to say it is I don't necessarily have all that information, but ultimately it's the prosecution that has the burden to prove to a jury beyond a reasonable doubt whether or not they could prove the charges that are submitted. In this particular case, there's a class 3 felony and a class 4 felony that were submitted. In this circumstance, the post plea agreement is a departure from that, though it is as allowed under the statute, one can be substituted if there is some reasonable basis to believe that it could be either shown and proven to a jury beyond a reasonable doubt or an appropriate substituted charge for that. The court does believe it is within the realm that is allowed under statute. Sir, go ahead and tell me your name.
Samuel Loka,
How old are you?
38.
Do you read, write, and understand the English language?
Yes, I do.
I have before me a plea agreement of the parties. It indicates that you're willing to plead guilty to count 3 assault in the 3rd degree, knowingly or recklessly causing injury, a class 1 misdemeanor. Counts 1 and 2 would be dismissed. You would be sentenced to 2 years supervised probation. You must comply with all standard terms and conditions of probation, and you must also complete successfully 16 hours boundary therapy class. You shall continue to comply with the mandatory protection order. Is that your understanding of the plea agreement in this case?
Yes, Your Honor.
Do you understand that you have a right to a jury trial in this case?
Yes, Your Honor.
Do you understand that by entering into this plea agreement today, you'd be waiving your right to a jury trial as to all issues?
Yes, Your Honor.
Is this plea voluntary?
Yes, Your Honor.
Have you had enough time to talk with your attorney about your case and this plea agreement?
Yes, Your Honor.
And are you satisfied with her services?
Yes, Your Honor.
Ms. Heisman, is there a factual basis set forth in the affidavit of probable cause, or does your client otherwise waive?
We waive, Your Honor.
Any objection from the people?
No, Your Honor.
Court accepts the waiver of the factual basis. Mr. Oga, is this the plea agreement you're willing to enter into today to resolve your case?
Yes, Your Honor.
How then do you wish to plead to count 3 assault in the 3rd degree, knowingly or recklessly causing injury, a class 1 misdemeanor, guilty or not guilty?
Guilty.
The court accepts the guilty plea. I do find that it is a knowing, intelligent, and voluntary plea. And given the record made, the court does believe it's a appropriate disposition under the circumstances. You should be able to go to immediate sentencing for the people. Do you want me to hear from victim first before we make any arguments?
Yes, Your Honor.
All right. Ma'am, again, as I told you before, I'm happy to hear from you. I don't know if you want to read a letter, you want to talk to me, but I'll just give you that time now. Go ahead.
Yeah, absolutely. I still have PTSD flashbacks of waking up in an unknown location, not knowing where my things were or how to get a strange body off of me. I've woken up exhausted from my mind spinning at the shame of trusting someone as a colleague and not seeing a trap set for betrayal. Sometimes I still scrub my skin a little too hard, trying to erase the thought of my skin ever having touched his. I have avoided community gatherings for years, even moving out of the country temporarily to feel safe from him. I've spent thousands on therapy sessions and healing sessions to help calm my anger and remember my own power. Unfortunately, my body keeps the score, and there's still more healing to do until one day I can wake up and not be triggered by the thought and embarrassment of having been violated by a trusted community member. However, it is completely unfair of me to have to hide myself and the gifts that I offer to the community for fear that I might walk into a space and be in physical or emotional danger. I should not have to carry the shame from a violation against me. I should not have to hide and will not as I fight for justice. People like him, unless they take accountability for their actions, will remain a danger to whatever community they are in. I never thought I would be one of the countless people who was violated by men abusing their power, but I am doing my best to reclaim my agency. I hope he wakes up to the part of himself that hungered so much it had to take. I hope he gets to truly meet himself and it transforms him. Until then, I just want to heal in peace, knowing I will never see him again.
Thank you, ma'am. Or we'll hear from the prosecution. Anything additional related to sentencing?
Your Honor, I think she spoke with grace and bravery, and I think she said it best. Thank you, Your Honor.
Thank you. For defense.
Thank you, Your Honor. But I submitted about 20 letters on behalf of Mr. Oga from community members, family, and friends, all praising Mr. Oga for what he does in the community. He is a leader and founder of the Colorado African Innovation and Cultural Center, where he mentors people in technology. Mr. Oga definitely strongly denies that he is a kind of a predator to people that he mentors. And so I did want to provide some of those letters to the court. We are asking the court to impose the sentence as agreed upon by the parties. We believe it's a appropriate disposition It will provide a sentence. It is not, he's not getting a case dismissed. There will be consequences, but he ultimately wanted to accept that rather than continue on with this matter. I will say for the court, there were proof issues. The detective with Aurora had some major malfeasance while she was investigating other cases, including this one. But ultimately, Mr. Oga wants to accept responsibility through this plea, move on, and accept this disposition. And we would just ask the court to impose the terms as agreed upon.
All right, thank you. Mr. Oga, you never have to make any sort of statement related to sentencing, but if you want to, now is your time. Is there anything you wish to say?
Your Honor.
All right, thank you. Court acknowledges the statements by the prosecution of some of the provability issues of the matter, particularly given some of the investigative aspects of that as well. The court also recognizes the defense statement that many, if not majority, perhaps even all of the facts would have been in dispute. Weighing both of that into consideration, the court understands that the victim is unsatisfied with the proposed disposition in this matter. The court completely understands that. I understand that the allegations presented from the victim and the prosecution are very different than ultimately what is settled on in the plea agreement here. That is not to say that it's not an inappropriate plea agreement. Again, there's a wide range of circumstances that may be held to be within the realm of what an appropriate disposition in a matter is that is short of trial. The long and short of it is the court does believe that this is an appropriate disposition, and I will accept it at this time. The court does sentence Mr. Oga to 2 years of supervised probation. He must comply with all standard terms and conditions of probation. He must successfully complete a 16-hour boundaries therapy class. He must continue to comply with the mandatory protection order. As noted, there is a civil protection order by the victim essentially against the defendant. The defense is telling me there's also a reciprocal civil protection order as well. For my purposes, the protection order in this matter remains in full force and effect throughout the duration of the sentence in this matter. The court has signed all the plea paperwork and is now in order of the court.